And I'd like to introduce our guest, Sheldon Slaybod. Sheldon has been a friend of mine for 25 or plus years. He is a fantastic divorce attorney. If somebody was to ask me who they should go to as the top divorce attorney in Northwestern Ohio, I would definitely say Sheldon. And as good of an attorney as he is, I think he's even a better person. Sheldon, thanks for being here.
Thanks for having me, Chuck.
So, Sheldon, let's talk about your journey. How did a nice young kid from Buffalo, New York, end up in Toledo, Ohio?
Well, I ended up here by coming to Toledo for law school. There were several law schools I was accepted to, and I came to Toledo, and I liked it. It was a brand new law school. I came with one of my friends from Buffalo who was going to attend Toledo, and Toledo is like a smaller Buffalo, a lot of green, um, not really Midwest people, but very nice people. The pace of living here is wonderful. Um, I just felt comfortable here. And when I came to law school, I did not plan on staying. But as being here for 3 years, I met people in the legal community. And I just thought, I'm here right now. And I never left.
So, when we're talking about your journey, Sheldon, why did you become an attorney?
Well, Chuck, it's a funny thing. Since I was a little kid, I wanted to be an attorney. I don't know why. My father wanted me to be a doctor and, pushed that all the time. My mother wanted me to be a corporate executive and an accountant. She pushed that all the time, and I resisted. There was just something about me at an early age that visualized myself as an attorney, and it just was a smooth transition. There was never looking back saying I should have done something different. Um, it's just made it easy for me.
So, how did you end up with divorce? I can't imagine as a little kid you decided you wanted to be a
No,
divorce attorney.
the divorce was um, at least a third into my career. I've been practicing for about 46 years, and when I started out as an attorney, I was an idealist. I was a civil rights attorney. I did criminal law, and I did very simple things like house closings, wills, and then litigate. I litigated um, in federal court civil rights cases and tried criminal cases. And then just somehow I transitioned into divorce without really thinking about it. My wife is my partner. We've been married about 36 years. And she, at 36 to 40 years ago, there weren't a lot of women attorneys, and there weren't a lot of women attorneys doing divorce. So, without soliciting divorce work, people called our office because they wanted a woman attorney. And then that's how it developed. And after a while, I think I started becoming good at it. I liked what I was doing. Um, Still do some other things, but I'm a divorce lawyer. And as time has gone on over the 46 years, the law and practicing law has become more specialized. And if when I started in 1975, it was simple to do a divorce. There were just very simple division of assets and what you did with the children. And as time has gone on, it's become more and more complex, and it's kept me interested. And that's why I'm here.
So, we've talked about your wife, Julia, in passing. Why don't you also talk about your kids and what their occupation is?
Okay, so my wife's an attorney and my partner. I have two boys. They're now in their mid 30s. They're both attorneys. One is living in Charleston, South Carolina. One is living in Grand Rapids, Michigan. And they love the law. My wife's father was an attorney, so my boys are third generation attorneys. Um, I'm not sure if there's a gene involved, but um, it's just a way of finding employment and being comfortable and liking what you're doing.
No, absolutely. So we're having you on basically to explain to people about divorce. So in Ohio, what is a marriage?
Okay, so the first thing, Chuck, is that we're going to try to deal with this at a fairly simple level. A lot of my answers will be general answers, and there's always an exception to the rule. But hopefully, by the time we're done with our conversation, most lay people will understand most of what happens in divorce. So if we could convey that to the people that are listening to this, we will have accomplished something. So the first thing is, before you can be divorced, you have to be married. And in Ohio, it requires that you have someone that's been licensed by the state of Ohio to marry you. Marriage is a contract. It's a legal contract. And with that, there's certain obligations and responsibilities. In Ohio, you no longer basically have common law marriage. If you were married, if you started living together roughly 30 years ago or so, then there's still like a grandfather clause. But right now in Ohio, to be married and in order to get divorced, you have to be officially married by the state of Ohio. So that's what a marriage is.
So could you describe, the timeline and, how things work as far as a divorce goes?
Sure. So if you want to get divorced, there's three ways to get divorced to have your marriage ended. The first is annulment. The second is dissolution. The third is divorce. With each type of method to end the marriage, you have statutes in Ohio that give you specifics concerning that type of way to end the marriage. So you have annulment. Annulment is rarely used, but it's still part of Ohio law. With annulment, you have specific grounds. So if you had a marriage that there was incest, if you had marriage of a child that was not 18 years of old, if you had someone that was already married, a bigamist, those marriages can be just ended by the court by annulment. The problem with annulment, it treats the marriage as if it never happened. So there's a lot of financial complications if you have an annulment. If you have a child and the marriage never took place, then the child is an illegitimate child. So the courts do not like to use annulment, but it's a possibility. The second way to end the marriage is by dissolution. That is no fault in Ohio. You don't need grounds in order to have a dissolution. You have to reach an agreement. The agreement has to be put in writing, and then the agreement plus the petition and court forms all get taken to the court. But the dissolution is the best way to end a marriage. It's the simplest way to end the marriage. It's the cheapest way to end the marriage, and it's the fastest way to end the marriage. But in order to do a dissolution, both parties have to agree to everything. Now, you don't have an annulment, you don't have a dissolution, so you have the good old-fashioned divorce. In Ohio, you still need grounds for a divorce. So to be divorced, some of the grounds are gross neglect, extreme cruelty, incompatibility, habitual drunkenness, adultery, living separate or apart from your spouse for a year or more without cohabitation. So those are the grounds. In our part of Ohio, the judges don't want to force people to be married that don't want to be married. So they're not going to, in most cases, spend a lot of time with grounds. because they want to make it easy. And grounds do not affect the finances. So it does not affect alimony. It does not affect property.
So
Now,
for example, if one of the people in the divorce was having an affair, you're not going to get additional money because of that.
no, none at all. And one of the people could be the worst person in the world. It's still not going to affect the financial part.
Can you describe like the timeline and the jurisdictional requirements for a divorce or dissolution?
Yeah. So in order to end your marriage in Ohio, you have to have some contact with the state. And for a divorce, you have to be living in the state of Ohio for 6 months and either in the county for 90 days or have some contact with the county for 90 days. So you might be living in Ottawa County, but working in Lucas County, and you would be able to file in Lucas County. So you have to have some tie to the state and the county. Dissolution, the same thing. You have to be a resident of the state of Ohio for 6 months and basically the county for 90 days, with some exceptions for the county. But in the majority of cases, it's, you're living in the county. Now, one of the things about a dissolution, and I previously said that it's faster, there are statutory time limits to complete a dissolution. So what the law says is that if you get all the paperwork completed and filed with the court, you have to wait 30 days, a 30-day cooling off period, before the court could set a final hearing. However, the statute says that it has to be completed in 90 days. So if it's a dissolution, the court cannot postpone it past the 90-day time limit. In a divorce, you file the divorce. If you settle the divorce, the court will set your case down for a final hearing and you could be over with. If not, you're going to have a series of various court appearances, mostly pre-trials, and it could take 1.5 years until the case is completed. Now, in a dissolution, since it's no fault and agreed to, you have one hearing in court that you have to attend, and that's your final hearing of dissolution. And at that hearing, the court wants to make sure that everyone knows what they're doing. Everyone understands the agreement. They've acted freely and voluntarily. We'll talk about whether you need an attorney or not in a divorce case. And there's certain regulations on a dissolution where you might not need an attorney, where in a divorce, you probably will be, so divorce is more complicated.
So just for clarification, if the marriage is in Ohio, the person lives in Lucas County, the spouse moves to Michigan, you could still file it in Lucas County?
Yes, if you still have assets here. Now, it becomes complicated when you're dealing with alimony and with children. If the children are living in Lucas County, then the court has jurisdiction. But if the wife or the husband have moved with the children to Michigan, and after a period of 6 months, then Michigan becomes the home state for the children. But once you file the divorce, and if you file the divorce in Lucas County or Wood County or Ottawa County, and you get the other party served with the initial papers, then that court keeps jurisdiction no matter whether or not the other party moves to a different state. So it's really your status at the time of filing that controls where the case will take place.
So it sounds like if somebody comes to you for a divorce or dissolution, there's a lot of strategy that the attorney can help the client with.
Yeah, so let's talk about it, whether you need an attorney or not, because that was a good lead in. Um, you don't have to have an attorney for a divorce or a dissolution or an annulment. People can do it themselves. With the internet, everyone could find out the basics of how to do a legal case. It's not that complex if the case itself is simple. Simple divorces, you probably don't need an attorney. If you don't have assets that you're worried about, you don't have children, it's a very simple thing to go through. The more you own, the more you owe. If you have children, then everything starts becoming complex. And it is good to have an attorney to help you through the process. If you can't afford an attorney, there's ways that you could get a free attorney. You could contact legal aid if you qualify economically. You could contact the Toledo Bar Association, where they have attorneys volunteering under a pro bono program that'll help you. And the Bar Association also has a legal clinic where I think it's once a month, they will hold a clinic and people come down and they'll explain the process and help you fill out the forms.
So what are the court costs to file a divorce or dissolution?
So I'm going to say roughly $350 to $450 in Lucas County. Other counties, $400 to $500. And that generally covers all of the court costs in the case. And why it's different, it depends if you have children. They charge more for children. If you're going to have a shared parenting plan, they charge extra for that. If you're going to add parties besides the husband and wife, they charge for that. So there's other costs involved for filing. If you go through a contested divorce, there's other fees if you have to have like deposition fees, or if you need to bring an appraiser in or have an expert testify to the value of an asset. But as far as the court's concerned, a good ballpark would be $400 for the cost of going through a divorce. And if you don't have money, you could petition the court to waive the fee. So they're not going to prevent poor people from getting a divorce. You have to fill out a form giving some basic information of your assets. And if you qualify, it's free.
So let's talk about some of the major issues in a divorce. I'm assuming that one of the biggest issues that you face on a daily basis is dealing with the issue of children. Maybe you could start talking and informing the listeners all the various issues regarding children.
So I could probably spend hours talking about all of the issues, but the beginning part is if you have children, the court has jurisdiction over the children, and the children and the court will decide where will the children be living after the divorce is completed, who is going to maintain medical insurance for the children or child, who's going to maintain the cost of non-covered medical expenses for the child support, who gets to claim the tax exemption for the children. So whatever you have an issue concerning a child, the court will make a disposition of that issue. Now,
So how do we decide child support? Like, is there any magic formula?
Child support, you got to talk about custody, because child support is directly tied into who has custody of the child. So in Ohio, you can either have mother having custody, which is called the residential parent and legal custodian, father being the residential parent and legal custodian, or shared parenting, which is the new name for joint custody. So that has to be decided. And if you have joint custody, shared parenting, doesn't mean it has to be 50-50 timeshare, but you have to put a plan together of how you're going to take care of your children. So that is the first thing that has to be decided in a divorce case or dissolution. Where are the children going to live? Now, As far as child support is concerned, you have a statute in Ohio, the Ohio Child Support Guidelines. Those guidelines determine how much money a person has to pay to support their children. It's based upon gross incomes with various adjustments. Some of the adjustments are timeshare. If you have a 50-50 timeshare, your child support is probably going to be reduced. If you have to pay union dues, that's something that's considered. If you have another child out of the marriage, that's to be considered. If you're paying child support for a child out of the marriage, that's considered. If you're paying for medical insurance for maintaining the children, that's considered. And there's also ways that you could average income over a period of years. The Child Support Guidelines statute on its face is simple, but in application, it really becomes very complicated at times. But there's computer software that does the calculations for you. If you're going pro se in the case, the court will run the child support guidelines for you in most cases. But whatever the child support is, that's the starting point. Now, there's ways to modify it if both parties agree, and there's also ways to modify it if the parties don't agree. It's called deviating from the amount that's set by the statute, and that's a case-by-case situation. There are reasons to deviate, and that's also in a statute that if someone's interested in, they could look at and find the reasons for the deviation. But once child support's established, it will be, and this is mandatory on a statewide basis, is that it will be withheld from your wages, paid to the Bureau of Support, and then paid to the party receiving it. They do charge you a 2% handling charge. You have to pay that. If you have to pay child support, it goes until the child is 18 or graduates high school, whichever happens later in time, unless the child is otherwise emancipated. And otherwise emancipated is only in a few cases. That's where a child under the age of 18 might be married. A child under 18 might have moved out of the house, is employed, and living on his or her own. There's only a few circumstances that a child will be emancipated before turning 18 and graduating high school.
One of the issues I know that people are always concerned about is child custody. How does the court decide who gets custody? I mean, what's the basis for that?
So the standard for custody is what's in the best interest of the child. And there are factors that the court looks at that are statutory. And some of the factors are what are the wishes of the mother? What are the wishes of the father? What are the wishes of the children? Who's been the primary caretaker? So you would go through the various statutory, requirements to determine who should have parenting time. The court has a standard. When I say the court, Lucas County Court, Wood County Court, Ottawa, in this area, the courts have standard parenting time. So a standard parenting time schedule is a minimal schedule that the court thinks that any parent that hasn't abused a child in any way or is not going to put the child in danger should have. And the basic court schedule is every other weekend from Friday at 7 to Sunday at 7, one midweek, usually on a Wednesday. It's usually for a few hours, but it can be an overnight. You have 4-week summer vacation, and you alternate court holidays. I believe there's seven holidays, and a parent gets to have the child, a father on Father's Day, mother on Mother's Day, and on your birthday, and the mother would get the child on her birthday. You can vary from that. That's always negotiable. And if you can't agree, Then you got to go through several different proceedings within the court till you end up at a trial, and a judge will decide what has to happen. When you have children, and this is in Lucas County, there are two requirements. You have to contact the court counselor's office, and the court counselor will interview you and talk about custody, parenting time, and attempt to work out an agreement between the parents. The second obligation is to attend the AOK program, which is a program that you don't really have to participate in, but you have to listen to. And it's a seminar that's 2 to 3 hours, and it talks about what children go through in a divorce and how you should act towards your children, and then how you should act to your soon to become ex-spouse. So those are the only requirements when you have children. And, it's the best interest standard, and that's very nebulous, and it's up to the trier of fact that's going to decide what issues are more important.
So is there a difference now compared when you first started practicing law? Like there's this perception that the wife is always going to get custody of the children. Is that a true statement or a fairy tale?
So it has changed. I've been practicing for 46 years. And when I started practicing, you had more women that were home as homemakers, housewives, and not into the job force. And they primarily took care of the children. And therefore, they would most likely get custody unless there's something wrong with the mother. As women have entered the workforce, the law of divorce has changed with that change of women being equal workers outside of the home. The statutes concerning custody say that women and men should be treated equally. And that's what a jurist is supposed to do. Whether it always happens that way, I'm not sure it does. And I'm probably not supposed to say something like that. But the reality is that you still see more women getting custody of the children. However, more and more cases are ending up in shared parenting, and the role of men have changed. So a lot of, I'll call them modern men, have participated in the child rearing more than the past generation. And men have changed diapers, men have fed the children, men have gotten up in the middle of the night, men have taken the children to school, men have taken children to medical appointments. And the more involved they are, the more likely they are to get more parenting time and to be named the residential parent or legal custodian.
Let's talk about the issue of division of marital property. Maybe you could explain that and the difference between marital property and separate property.
Yeah. So again, the initial part of the explanation is going to be simplistic, and at times it gets to be extremely complicated. But the basic rule is that property acquired during the marriage is marital property. That's the presumption. And it doesn't matter how the property is titled. It doesn't matter who earned the money to obtain the property. If it is acquired during the marriage, it's marital property, with the following exceptions. And that is, there's an exception for separate property. And if it's separate property, means it goes to one of the people without compensation to the other. So some of the areas of separate property are: one, you had it before the marriage and you still have it. So if someone had a doll collection and they still have the dolls, that's their separate property. If someone had a coin collection or baseball card collection, tools, that's separate property. If someone owned a car before the marriage that was paid for, that's separate property. Part of your retirement that you earned prior to the marriage is separate property, and the part that you earn during the marriage is marital property, and the part that you earn after the marriage will be your separate property. So if you owned it before, that's one category. If you received an inheritance and you kept the inheritance separate, that's separate property. If you had a bank account before, or owned stock, or any financial accounts, and you kept it separate, then that's separate property. If you received a gift, and the gift was to you and not to both of you, that is separate property. So if the wife gave you a tie, that is your property, not subject to division. If you gave the wife jewelry, then that's her property, not subject to division. A hybrid, and this is something that Chuck gets involved in, is what if you receive money from a personal injury case or a medical malpractice case? Is that marital or non-marital? And when I say it's a hybrid, it's part of each. So any compensation you receive for property, marital property that was damaged, is marital. Any compensation you receive for lost wages that took place during the marriage is marital property. However, any monies you receive for pain and suffering is non-marital property. Any monies you receive for future wages is non-marital property. So sometimes property becomes very complicated, and you have to go through the tracing of when you received the money, and can you go through and show how it was transferred between different assets to keep the nature of it as being separate property. That's something a lawyer could help with. That's something that's complicated, but it's simple.
So something complicated. If you go into the marriage with $500,000 worth of stock and it appreciates $1 million during the marriage, is the appreciation a marital asset?
So passive appreciation is separate property. However, if it wasn't passive, then it becomes marital property. So you'd have to look at the original money, see how much is passive, and then how much is active. So if you just had the money invested in stocks and it appreciated and you received dividends and you kept everything separate, that's all non-marital. But if you become an active stock trader during the marriage, that you're spending time each day buying and selling stocks, and you have your $500,000 appreciated to a higher amount, then the higher amount, the appreciation, could be considered marital property. You still protect, if you could trace it, your original $500,000. So you're not going to give that up, but it's a question of, what you've earned on that money.
And I think the point that you're making is, the more, like you said, the more assets you have, something that starts out as simple becomes extremely complicated.
Yes, and what becomes complicated in divorce is if someone owns a business, what's the value of the business? How do you divide a business up? So that's probably the most complicated part of divorce, is when you have various businesses to divide up.
Let's talk about the payment of debts. Could you explain that?
Yes. So just like you divide the assets up in a marriage, you also have to divide the debts up. Dividing some debts up are easy, others are more complicated. So if you own a house, the value of the house, the fair market value of the house, is what can you sell it for? If you have a note and mortgage on the house, that's what you owe on the house. So with the amount that's owed, if you're going to get the house, you're probably going to have to pay the debt of the mortgage. If you have a car and there's a car loan, well, the value of the car is the fair market value minus a mortgage. So that's the equity, but you have a debt on it. So it's usually who will receive the object will be responsible for the debt. So the standard for the division of debt and also the division of assets, the starting point is equal. But a court can look and see what's equitable. And that confuses people. What's the difference between equal and equitable? Well, equal, I think everyone understands, you each get 50%. Equitable is you start off with 50%, but you do something that's fair. So it might be fair to have a 45% versus 55%. So in the allocation of debt, you have to look at it and see, is it marital debt or non-marital debt? So non-marital debt was prior to the marriage. Do you have the debt and you still have the debt? That's probably going to be your debt that you brought into the marriage. When you deal with school loans, that's pretty much an exception in most cases to make that non-marital debt. But like everything else, it's not simple, because if you received a student loan and you use the money instead of paying your tuition and books and you used it for marital living expenses, then you might have part of that debt being marital and the other part being non-marital. So what the court tries to do is look at the overall picture, dividing up the assets and the debts, and to try to come out with a fair solution, in each case, based upon the particular facts.
So another topic that I think is misunderstood by most people is spousal support and alimony. I think there's a perception that it's given in an unfair manner. Maybe you could explain that.
So I find the payment of alimony / spousal support as being the most difficult part of being a divorce attorney. And the reason for that is the statute is very vague. The standard for paying alimony / spousal support is what's reasonable and appropriate. Now, why I say spousal support / alimony or alimony / spousal support, under federal tax law and former Ohio law, it's called alimony. The Ohio legislature changed the name to spousal support, thinking that people would feel better about paying spousal support than alimony. It's really the same thing. So if I go back and forth, it's just the context I'm thinking about, whether it's a tax issue or just a payment of support. So because it's reasonable and appropriate, that's vague. There's a statute that says, here are some factors that are going to help you figure out whether or not there should be spousal support paid. Length of the marriage, mental health of the parties, physical health of the parties, emotional health of the parties, age of the parties, income from all sources, whether one party is a homemaker that prevents that party from going into the workforce, retirement benefits to the parties. There are other factors too, but those are the main ones. So you can't convert that into dollars. Child support, you have a statute. You put in gross incomes, you put in the exceptions to it, it comes out, and that's what it is. So alimony is a case-by-case computation. And it's basically what people agree to, and they think that's fair if they can reach an agreement themselves, or a court will determine what the court deems fair. So what you're going to find in a marriage of a couple of years, there's going to be no alimony, or for a short period of time. People that have been married 30 years or approaching retirement, that type of support will be until the retirement or until death, depending on the situation of the parties. And in between, it's some length of time. For some reason, in that middle period, alimony is calculated with a formula of 1/3 the length of the marriage. So if you're married 9 years, it's 3 years. You're married 18 years, it's 6 years. There's no logic to it, but it seems like most judges use that formula. Most attorneys use that formula. The different jurisdictions use that formula. So if you're trying to estimate, that's what it would be. But if you're really going to be trying to calculate it, then you go, this is where I think an attorney is usually needed, or at least a CPA. You take wife's gross income minus her taxes, whether or not she's going to be receiving child support. You look at husband's side, what is his gross income minus his taxes? Is he going to pay child support or receive child support? You look at his side, you net out the income. Then you look at a comparison of those incomes, and then you look at what debt each party's going to have after the marriage. And then you look at what are wife's expenses, husband's expenses, and you look at the difference and you try to negotiate that sum. There's no way to predict what's going to happen on it. But I know if someone's not working and someone's making $100,000 a year and they've been married for a certain period of time, that there's probably going to be spousal support / alimony, and it's just a question of how much.
So another question that people have is, if I file for divorce or dissolution, am I going to have to testify in a deposition or in court?
So let's start off with a dissolution. Dissolution, everything is agreed to before you file the case. So there's going to be no mandatory hearings other than one final hearing. If you file a dissolution, both parties have to appear. Right now, most of the courts are still having hearings by Zoom, by online computer, with the judge in one place, the attorneys and the parties in another place. And that's just a routine hearing. What the court wants to do is make sure the court has proper jurisdiction, that people have agreed to how they're going to take care of their children in the future, that they've made a total disclosure of all their assets, total disclosure of all their liabilities. If some party's not represented, the judge is going to talk to that party and make sure they know what they're doing, give them an opportunity to get an attorney if they want it. The court's going to want to make sure that all the documents have been read and understood. And the court wants to make sure that both parties want to terminate the marriage. So, and then the judge will sign the final papers. So that's the dissolution. In a divorce, the divorce starts by filing a complaint for divorce. So in the complaint for divorce, you allege grounds, and you state your jurisdiction, that you've lived in Ohio for 6 months, the county for 90 days, and then you tell the court what you want: custody, visitation, payment of bills, child support, spousal support. And then that complaint is served on the other party. Once the party receives the papers, the case is started. Now, with COVID, a lot of the court hearings have been suspended, and now the courts are starting to open up again, and there's more hearings. So there can be a hearing in the beginning of a case for temporary orders. If you file a divorce and you're not going to have a final hearing for a year and a half, well, how do you get by? Who has custody? Is there going to be child support? Is there going to be alimony? Who's going to pay the bills? So the court has a system and a procedure to have temporary support, custody, payment of bills ordered. Now, in the past, you would have to be present for a hearing for that. Right now, the hearings are either by attorneys on phone or by Zoom, and you have no initial hearings. In the process of a divorce, each side has a right to get information from the other side. I want to know, if I'm representing the wife, what does husband own? What bank accounts does he have? I might want to know information if he has a business. I might want to know if he has a pension. So I could send written questions to him, but maybe I don't get the answers I want. So I have a right, just like in any other civil lawsuit, to request a deposition where you force the other side to come into your office, be put under oath, and questions asked. So in simple divorce cases, you're probably not going to have a deposition. You're not going to spend the money and the cost of having a court reporter and attorney spending their time figuring out the value of pots and pans. If there are disputed issues on marital and non-marital property or on the business, dissipation of assets, then there very well could be a deposition, and you have that cost, and you have to appear. And in a divorce case, you will have to appear for a final hearing. If it's a settled divorce, it'll be very similar to a dissolution. If it's a contested divorce, you have to be there for the entire trial of the case.
So Sheldon, thank you for this.
There are no jury trials in divorce. So if you're picturing yourself going through a trial in a divorce, it's just the judge, the attorneys, and the parties. There's no jury involved.
Thanks for the overview. So let's say an individual watches this and wants to reach out and contact you. What would be the best way of doing that?
Well, right now, since we're working mostly remotely, it would be our email address or our phone. If you call our phone, it'll say, we're not here right now. Contact us by email, or you go directly to our email address. We're very good at getting back to people and responding. And we're showing up in the office more now as things become safer.
Thank you very much for your time, Sheldon. And if anybody has any additional questions, feel free to reach out to Sheldon. And once again, he'd be my choice as the most knowledgeable divorce and dissolution attorney in Northwestern Ohio. Thanks a lot again, Sheldon.